two sets of questions, really, in a way. One is in this question of renegotiation. It does seem to be, you mentioned that CETA was a test, and things do seem to have moved in a different direction since then. When we talk about an example, it seems the EU-China deal, as you have said, the EU-UK deal, all of them, they have maintained dispute mechanisms, but only between the parties who have actually signed up to the treaty. So the South Korea example, for example, is dispute resolution between the actual signatories of the treaty. But the EU-China deal, the EU-UK deal, and very interestingly, to a large extent, the new US-Mexico-Canada deal have in fact chosen not to give dispute resolution protections to investors. They have reserved the dispute mechanism solely for the parties who are actually signatories and indeed signed up to all those other parts of the deal. So it strikes me that the tide seems to have moved in a different direction, as you mentioned yourself at the beginning, and it is the case that investor dispute mechanisms are no longer being added into trade deals. It's interesting, the US-Mexico deal, I think, is an example when we come to renegotiation, because NAFTA took 13 years to negotiate. The renegotiation took 2.5 years. And it strikes to me that as part of the changed landscape, the fact that the EU Council and the EU Commission are, since the Singapore ruling, empowered to negotiate would mean that actual renegotiation could be proceeding and could even be certainly explored during the period of ongoing provisional application that we have on the current deal. I think it would seem to be a reasonable thing to look at. Could a better deal be constructed while continuing with this? And in that regard as well, another area which is not just a matter of renegotiation, but in fact ongoing negotiation, is in relation to the investor court system itself, because the text and the operation of the investor court system is not finalised. As I understand it, the joint committee under CETA can continue to review the practices in relation to that. And in fact, in the European Court of Justice ruling from 2019, the European Court of Justice actually said, they quoted that the Commission said they would further review, without delay, the dispute settlement mechanism, allowing sufficient time so that member states can consider that in their ratification process. Now, we haven't had that review, as I understand it, yet. The review was specifically around small and medium businesses and their equitable access. And it was specifically also around the costs associated with taking a case. You mentioned that they are permanent, but of course there's a very expensive per diem attached to each day of the case, and we do have details on that. So it strikes me that there's actually a negotiation ongoing in terms of how we improve the ICS structure, as well as scope for renegotiation. And then the core issue, which is I think the key thing for me, is in relation to regulation. There is of course a right to regulate. I think there's sometimes a bit of a red herring, but looking at CETA itself, it is clear of course that you can regulate, but companies can also seek compensation. And that's made explicitly clear because in the section on regulations, it says the mere fact of regulation does not amount to a breach. But in the section of withdrawal of subsidies, it explicitly says that the party would not be required to compensate investors. So in one section, there's a protection against compensation in terms of subsidies. There's not a protection against compensation claims in respect of regulation. And you mentioned that there's cases have been very, member states have taken cases, but of course the key point here is the chill effect. And I think that is the core of what will happen in terms of regulation. And I know, in fact, you mentioned that you're not a lawyer, but I know that you are a senior counsel, indeed, in terms of working with Steptoe and Johnson. And just quoting from Steptoe and Johnson's own website, they say about bilateral and multilateral treaty investment protections, these protections may be a highly important tool for foreign investors and industry associations in advocating against legislative changes to renewable energy regulations. It may well be possible to use such protections as a tool to assist lobbying efforts to prevent wrongful regulatory change. So that is in that context. And when we talk about fair and equitable treatment, your own company describes that as a very wide protection. And it explicitly says it may be breached by frequent occurrence of regulatory changes which undermine the stability and predictability of the business environment for investors. Now, I'm interested in a number of areas, labour rights, the environment, but I am very concerned if we have companies who are looking to what fair and equitable might be and saying that frequent regulations, which is certainly something we're going to see in certain areas. So again, in that regard, is it not the case that the chill effect is there? Is there not a giving of an undue power in terms of a threat of potential litigation and compensation in respect of potential necessary citizen demanded regulation? Thank you.